Heller involved, there's more. Heller involved a federal law. The District of Columbia is a federal district. So when the Supreme Court decided the Heller case, all it decided was that as far as federal law is concerned, this is what the Second Amendment means. But there's a second question, there's more. Would the Heller case then be binding on state and local governments? Recall, I mentioned this in two other classes, in 1833, the Supreme Court in Barron versus Baltimore held that the Bill of Rights, the first 8 amendments, only applies to the federal government because it says the First Amendment starts, Congress shall make no law. And the intent of the Bill of Rights at the time it was drafted is that these were protections that protecting the citizenry from excesses by their new federal government. The whole problem with the ratification of the Constitution was that it was feared that it would give the federal government, the new national government, too much power, that it would override the protections contained in their state constitutions, and they wanted protection for it. Madison, who originally disagreed with that, by the way, he said, look, the federal government's a government of delegated powers only. If it doesn't have the power to do something, it can't do it. You don't need this. But then he realized that there were so many people who were opposed to the new Constitution, principally because it didn't have a Bill of Rights, and because he didn't think it cost anything to put one in, he agreed to do it. And he did, and doing that got both New York and Virginia's conventions to ratify the Constitution. So that was the Supreme Court, when it held in 1833 that the Bill of Rights only applied to the federal government. That was in fact what most people believed and understood, because the actions of state and local governments that affected speech, religion, criminal procedure, and individual rights were determined by state laws. And as I've noted, all of these early state constitutions had Bill of Rights in them. Maybe I'll do a class sometime on the origin of the Bill of Rights, and you'll see where this will come in. For decades, and so then in 1869, the 14th Amendment was ratified. And for decades after that, the Supreme Court held that the 14th Amendment didn't change the basic rule. Following the 14th adoption, the Supreme Court limited its application only to instances where states and local governments passed laws that expressly and overtly discriminated against one class or group of citizens. It didn't create an affirmative right of action to prevent discrimination in the way laws were executed. And as late as 1922, the court reaffirmed that state infringement of civil liberties remained beyond the control of the federal government or its courts. That was the rule as late as 1922. Now, the first break in this came in the context of free speech. A guy named Benjamin Gitlow had been convicted under New York State's Criminal Anarchy Act for publishing a, quote, left-wing manifesto, close quote, that argued that World War I and conscription were constituted immoral, capitalistic oppression of the masses. Now, I mean, but remember, this is the time of the Palmer raids and et cetera. And he was found guilty in New York State Court. In Gitlow versus New York in 1925, the court upheld his conviction on the facts. And by the way, Justice Holmes gave a famous dissent in that, where he said that, you know, come on, guys, how is some, you know, left-wing guy publishing a newspaper that 13 people might read harming anyone? But in any event, the conviction was affirmed, but the court acknowledged that freedom of the press and free speech were so important that they were fundamental rights protected by the Due Process Clause of the 14th Amendment from impairment by the states. That's a quote. Fundamental personal rights protected by the Due Process Clause of the 14th Amendment. Now, this is the first time the Supreme Court put forth what became known as the doctrine of incorporation, that the 14th Amendment incorporated a right protected in the Bill of Rights, those to thus make it binding on state and local governments. Now, a few years later, 7 years later, the Supreme Court did it again in the case of Powell versus Alabama. Many people might know of this case. 9 black teens, the Scottsboro boys, were accused of raping 2 white girls. They were railroaded in a one-day trial and were sentenced to death. Now, Alabama law required appointment of counsel in capital cases, but their appointed lawyer never consulted with his clients, never put forth any evidence on their behalf. The Supreme Court reversed all the convictions. The court held that the lack of effective counsel and the trial court's blatant disregard for fairness violated the Fifth Amendment's due process clause, the right to counsel as provided in the Sixth Amendment, and the due process clause of the 14th Amendment. For the first time, the Supreme Court invalidated a criminal judgment because a state court violated a defendant's rights protected by the Bill of Rights, the procedural rights that constitute a fair trial. But there's still an open question. What determines which rights in the Bill of Rights would be incorporated? In Palco versus Connecticut in 1937, the court held that the First Amendment's protections of free speech, free thought, free press, and the right of association and religion are, quote, indispensable conditions, close quote, of freedom. But as to the Second through the Eighth Amendments, the 14th Amendment would only incorporate those rights that, quote, are of the very essence of a scheme of ordered liberty, close quote, and quote, so rooted in the traditions of conscience that are of our people as to be, quote, as to be fundamental, close quote. In other words are being used by the court to describe when the incorporation document applied were, immutable principles of justice and rights deeply rooted in our nation's history and tradition. Now, these are not objective standards. They're inexact, subjective formulations. So it's up to the court to decide what applied to the states and what didn't. And in cases decided between 1925 and 1972, one by one, the incorporation doctrine was applied to every clause in the First Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment. And as to the Fourth Amendment's search and seizure provisions and the Fifth Amendment's right against self-incrimination, the court went further and said that not only are these doctrines incorporated, but the remedy for breach of these documents is incorporated, and that remedy is the exclusion of evidence. That you can't just say the right was violated. You have to exclude any evidence that results from that violation. And that too is required by the 14th Amendment. Now, the Third Amendment deals with quartering troops in private homes, and that's never come up in our history. And the Seventh Amendment deals with jury trials in civil cases. And that clearly applies to the federal government or the state governments, but that's not an issue. Every state allows jury trials in civil cases. So after 1972, only the Second Amendment hadn't come before the Supreme Court. Now, on the list of cases that's going to get posted, I've put all these cases that deal with the incorporation document that I haven't mentioned by name, there's a ton of them, as a separate list, because my first draft when I prepared this lecture included each one of those, and I realized that's just naming too darn many cases. Okay, a year after Heller, the court gets a Second Amendment case arising under a local law, Mcdonald versus City of Chicago, which was decided in 2010. Here, Justice Alito wrote the opinion for the same 5 justices who were the majority in Heller. The court held that the Chicago City Ordinance violated the due process clause of the 14th Amendment, and that the 14th Amendment and that the Second Amendment was binding on the states through the 14th. Mr. Mcdonald was a 70-year-old man who lived in a high crime area, and he wanted to have a handgun in his own home for protection. But Chicago's law, city ordinance, banned handguns that weren't registered. And registration was severely limited, such that if you wanted to have a handgun in one's home, you had to make sure that it was inoperative. You had to basically take the bullets out and take the cylinder out and take the firing mechanism out if you were going to have it in your home. So Alito cited Heller as precedent that the Second Amendment created an individual right to bear arms independent of any connection to the militia. And he found that gun ownership unconnected with organized militias was so deeply rooted, and this is quote, deeply rooted in our nation's history that the 14th Amendment incorporated the Second Amendment. And he noted, maybe with some bemusement, that for years, Justices Hugo Black, William O. Douglas, William Brennan, and Thurgood Marshall, who back in the 60s were the most liberal justices, all argued that the 14th Amendment's due process and equal protection clauses operated as a blanket to totally incorporate all of the Bill of Rights. So quite frankly, if you're being a little disingenuous if you say that the Second Amendment of all of the Bill of Rights should not be incorporated. So in effect, once Heller establishes the Second Amendment protected a personal right to bear arms for any lawful purpose, it was almost axiomatic that the same court would hold it equally applicable to all levels of government. And as I said, gun control is at heart a political issue. Blanket prohibitions of all of handguns necessary or deemed necessary personal use are not going to fly. But states and cities can limit or ban open carry, assault weapons, the large magazines. Ammunition can be made traceable. A law that required a serial number to be put on every bullet casing that would allow tracing of the scene. It would be perfectly legal, but it would take a lot of political will to pass it. Ammunition and guns can be registered. Background checks can be required. Gun shows and other non-traceable sales can be controlled and made traceable. All it takes is a political will to enact the laws and impose sufficient tax revenues and fees to fully enforce it. So that's where I think this stands. I think that we are stuck with the fact that the Second Amendment is incorporated by the 14th, and the 14th, and as such, that a blanket prohibition of personal owning of a firearm is not going to fly. It can be regulated, and it can be regulated so as to limit the possession and use for a lawful purpose under reasonable conditions. But you can't go farther than that. I think that if you're going to try and make it like England, where non-ownership is the rule, and that you have to have special purpose and reason to own any kind of a weapon. And for handguns especially, it's virtually impossible to get a permit in England, very difficult to get a permit in England to own a handgun. That's just not going to happen in the United States. So that's my take on the Second Amendment. And questions, I finished that section a little faster than I thought, but the next one's going to take more time.
I see a hand for Nancy. Where are you? But I don't see where you are. Go. Oh, there you are. Go ahead.
Hi, Nancy.
Here I am. Thank you very much. That's been really interesting. So now I've read that in the at least the first half until the Civil War, the main purpose for militias in the southern states was to catch runaway slaves.
That was the main job they were tasked with, yes.
Yes. Could you discuss the history of that and how that has managed to be suppressed as the motivating factor for these militias in so many of those states?
Okay. From the very beginning, and remember, up until about starting in about 1805 to 1819, most northern states had not yet outlawed slavery as well. It was outlawed in the Trans-Appalachian region north of the Ohio River under the Northwest Ordinance, But like to give you an example, New York in 1815 had more slaves than Maryland. People don't realize that. They were just used differently. There were about 30,000 slaves in the city of New York working basically as personal house servants. And ultimately that changed. But what happened in the South, that in order, especially even before the Revolution, slave revolts had happened, they were feared. And of course, once the slave revolt in Haiti occurred, then it became, slave societies became paranoid over that. And in order to prevent that, they passed black codes in most slave states that banned literacy among that made it illegal for slaves to learn to read and write, banned literacy, made it a crime to teach a slave to read, banned gatherings of slaves of more than a certain number of people without permission, banned slaves leaving their plantations and their owners without a pass, and regulate and so in order to enforce those regulations, Southern slave states charged local militias with the responsibility of enforcing them. So you had basically slave patrols, generally at night, that patrolled the rural areas and the plantation areas to make sure that these rules were being enforced. And remember, there's no national standing army of any size. You know, when Jefferson, after the War of 1812, when Andrew Jackson took over, the armed forces of the land forces of the United States, under the control of the United States, was less than 3,000 men. And so law and order, local order was up to local jurisdictions. And in the South, you didn't have state police constabulatories. What you had are local militias, usually organized on a county basis. This goes back to even before the Revolution, where in Virginia, each parish had three things. It had a church, it had a poorhouse, and it had a militia. Mm. And the purpose of the militia was Indian raids, because the frontier was right up there, and order, preventing Indians, and preserving order. When you look at the U.S. Constitution, there's coded language in there that deals with slave revolts. One of them is in the preamble, which is to ensure domestic tranquility. And then you go to Article 1, Section 8, among the delegated powers of Congress, is to provide for calling forth the militia to execute the laws of the Union to suppress insurrections and repel invasions. What does it mean to suppress insurrections? What type of, are they really worried that white citizens are going to rise up against this new federal government?
But that could happen now.
That's right.
Well,
that could happen in November.
Yes, one can see a doomsday scenario coming forth, and I'm not going to poo-poo it, but I'm on the other hand, I'm not going to stay up at night worrying about it. But that's the background. And so and of these state militias throughout the South, there was the state of Virginia, local counties. Most of the local counties did not have large armories. Those that did, New England was one area where New England counties did have armories. That's why Lexington and Concord, Paul Revere's ride, what were the British trying to do? They knew that local militias had stockpiles of arms secreted in certain areas in Lexington and Concord, which are outside of Boston. and they were going to try and go seize those. But throughout most of the young United States, that was the exception, not the rule.
Mm. Thank you.
Do I
Great.
see any other hands?
My kids used to say, "Can we have a short answer?"
That was a great answer. Thank you.
Yeah, I'm reminded of a line in the movie Lincoln where Daniel Day-Lewis says, "You know, he reminds me of a sermon who once said I could write a shorter spur sermon, but I just get too lazy to stop."
That's Mark Twain.
Yeah, was that Mark Twain?
That's Sandy, have a question?
Yeah, I find that interesting, that question that was just asked about the suppression, about the slavery, because I was just reading about the Electoral College also being developed with the slaves counting as 3/5 so that the South would have an equal.
No, it wasn't equal, it was more.
More, it was much more. And so slavery is embedded in our Constitution.
Oh, yeah. And as a matter of fact, there's a book by a historian, Richard Wallstreicher, called Slavery's Constitution. It's a fairly recent book where he goes through it. And yes, it's replete throughout. It's replete throughout this. And when I talked about the Dred Scott case, I think I went over some of those provisions and how it happened. The 3/5 rule was a compromise in the Constitutional Convention that was based on earlier compromises worked out in a number of states, for dealing with apportionment. Because remember, slaves were not considered, quote, people for political purposes. A slave had no political life. He could not vote. He could not make a contract. He had no right to own, or he had no right to own property. He had no right to enforce a promise. Whatever he owned could be taken. He and anything of his was the property of his master. He had no right. A male slave in a marriage, in a relationship with a woman, had no right over his wife, to control her labor as a white husband would under coverture. Neither parent had any right to control their children, except as may be allowed by their master. And so, but the Southerners were concerned that the northern jurisdictions were much more urban and would outgrow them. And to preserve they wanted some recognition in the government, some political recognition based upon all these slaves. And the compromise that was worked out was the 3/5 rule, that when apportioning the House of Representatives, each slave would be counted as 3/5 of a person for determining how many representatives that state would get. Now, since the Electoral College is based, each state gets one vote in the Electoral College for each congressional district, plus one vote for each senator, then therefore that 3/5 rule is transferred over to the Electoral College. The issue today in the Electoral College is that if the Electoral College was strictly based on each congressional district having one vote, and if that vote for that elector was based upon who won the popular vote in that district, you wouldn't have a problem. The problem is that when you look at the Electoral College today, 60%, because of the two representatives in the Senate from each state, regardless of population, about 55 to 60% of the votes in the Electoral College are awarded to states that combined have less than half the population in the country. That's where the problem is. Now, some states have passed laws that say, we'll give all of our votes to whatever candidate has the most popular vote, but we'll only do this once 281 electoral states with a total of 281 electoral college votes agree as well, because then it'll take effect. So that's the problem with the Electoral College. Will the Electoral College ever be abandoned? Not based on a constitutional amendment proposed by Congress. It would take a constitutional amendment to do that. And if there's anything that I'm totally afraid of, it's a constitutional convention, because it will set loose every wild-ass political extremist view in the country that will then have. And you could have a situation out of a constitutional convention that, based on the strength of evangelical Christianity in this country and so forth, that I think you could have a substantial change country that would have a total, that would just be horrible. I'm deathly afraid of a federal constitutional convention. The only reason the first one worked, in my opinion, is because they agreed to close the doors and not let anyone know what they were talking about or what they were voting on until they had a document that they presented. And there's no way that could ever happen today. That's my take on it, as someone who studied this stuff. But believe me, I'm just one voice.
I don't
Can I
think
ask a question?
Yes,
Who is that?
that's Lou.
Larry?
Oh,
No.
Larry.
Yes.
Go ahead.
Since going back to the slavery and the issues about the militias and so on, the other day I was having a discussion, and my daughter-in-law, who's in her 30s, brought up the point that Abraham Lincoln, who signed, obviously is known for the Emancipation Proclamation, during that time was actually a white supremacist who supported slavery. And in the Emancipation Proclamation, there was still a lot of things in there that still allowed for slavery. Is that true?
The second part of it is true. I don't think that he was a racist.
Not
Certainly,
racist. Well,
maybe
white-
by today's standards, but I think if he were alive today, he would not be. Remember, when Lincoln became a political animal, his political thinking was based upon the culture that he grew up in the early 19th century. He also understood that there was not the political will in the United States to eliminate slavery in those jurisdictions where it had been allowed. And up until 1861, Lincoln understood that states had the right, understood that under our Constitution, this was a state issue, not a federal issue. And he knew that there was not the political will in the country to change that. Also, it was pretty much understood culturally. It was the cultural assumption that biracial, multiracial societies don't work. There was no experience with a true multiracial society. The only large accumulation of free non-whites in the United States were in a number of eastern cities. But there were very few free blacks living in rural Indiana and in rural Illinois where Lincoln grew up. And as a matter of fact, and most people did not believe that the general view of most white people, even if it was wrong, were that this will not work. And so the American Colonization Society was formed, and Lincoln was a member of it, as were most non-abolitionist, non-emancipationist Whigs. It was founded by Henry Clay, who was from Kentucky, and the idea was that if we're going to eliminate slavery, we need a place. These people need a place to go where they will be welcome, because they won't be welcome in the United States. Whites were not prepared to accept it. Now, Lincoln's view changed over time. The Emancipation Proclamation was founded and it only applied to states then in rebellion for two reasons. First, Lincoln knew that at the beginning of the Civil War, if Kentucky and Maryland were to join the Confederacy, the Union would have lost. That the Union could not survive without those, if the border states left. That foreign countries would put pressure on this, and the United States, as they knew it as one country, would be divided into two countries, a slave country and a non-slave country. And so the Emancipation Proclamation reflected that fact. But then Lincoln became the most fervent a supporter of the 13th Amendment, which ended slavery. Lincoln was a politician. Lincoln was not, William Lloyd Garrison was an idealist. And even Frederick Douglass was an idealist. They felt that there's the difference between right and wrong, and political reality, and the political will to make it right was irrelevant. If it's right, you got to do it. Period. End of discussion. Don't give me this political amount of political will to do it. Lincoln was a politician, and a very crafty one. And he knew that the only way to get things done in politics was to win. So I'm not sure if that answers your question.
Yeah.
So,
But that's how I would respond to your daughter. I think that to separate Lincoln from the time in which he lives, to say he was a racist, well, then you could say the same just about almost 95% of the 95% of white people living in the United States in 1855 were also racists.
Right. Well, and that's kind of what I read something about it and followed up on it. Particularly like in 1978, there were some black historians that wrote some things about Lincoln. And they said exactly that he was doing what was popular at the time. White supremacy was the popular mode in the 1850s.
It wasn't really a function of popular.
It was needed.
It was ingrained in culture. And that's
right.
something, and that takes time to change. And we should I want to take a break because it's 11:05.
yes.
But the next half that we're going to talk about is going to deal, and there's going to be an example of a cultural shift that happens over a period of time that in historical terms is light speed. And so let's take a break. Let me have a
5
few
minutes. Yeah.
and we'll come back in 5.
Okay.
Thank you.
Speaking of a sentence here, a sentence there, that I had not heard before, but I'm wondering when it changed. And that was, you said that every parish had a church, a militia, and a poorhouse.
Yeah.
When did we lose the poorhouse?
Well, actually, we lost the poorhouse probably right along with, kind of hand in hand with it's kind of the dark side of the Protestant ethic. The Great Chain of Being said that, and Puritan theology was that, everybody's got their place in the world. It's ordained by God. And that also that salvation was determined by God. That you didn't know if you were going to get saved. You can't earn salvation. It's predestination. The omniscient God knows who he's going to save. He's already made that decision. And all you can do is do the best you can. And so that therefore there was a collective idea that the community is responsible, that poverty itself is not a sin, and it's not a sign of a failing of character, and therefore the community has an obligation to help take care of people. Well, there's a dark side of the Protestant ethic. If you come into evangelical with the changes in Christian doctrine and the end of Puritanism, Puritan doctrine, and you get the idea that salvation is yours to achieve, and you achieve it simply by surrendering your life to Jesus, and it's a matter of your choice. That whether or not you are saved or not is up to you and the way you live. If it's yours, if salvation in the next world is your responsibility, then so too is is how you get along in this world and your success or failure in it. And if you go back and look, think of that quotation I gave you from Lincoln when I talked about the free labor ideology. And Lincoln said that, you know, the young man starts on his own, et cetera, and he works hard, saves his money, hires somebody, and moves up in the world. That's free labor. And if one remains as simply as a lowly wage worker throughout his life, it's due to either inadvertence, character, a flaw in character, or bad luck. So in other words, poverty can be a problem. That can be your own problem. And once that happens, you see an end of the idea that the communities are responsible for saving. That and it became true in England too, with Methodism. That the idea that, you know, if we give the poor too much help, they're not going to want to work. So that's where it went.
So
there is a connection. Yes, Lois.
So there wasn't a school. School wasn't one of the.
No.
How?
No, most southern states didn't even have public schools until the 1870s and 1880s, and very few of them did, and they didn't give them a whole lot of money, and there was a lot of resistance to it. It took, you know, for poor white, it took the kid. They needed the kids at home to help on the farm, and so even in the North. What we think of as the public school movement really came about in the latter third of the 19th century.
Right. So in a sense, that goes back to last week's discussion. And I keep thinking that schools are still unequal as long as they're funded the way they are.
Okay, it's 13 after, and I got a lot of material to go through. So can I ask that everybody, Mark, would you mute everybody, and I'll unmute myself and get going?
Absolutely. Done.
Okay. So now we're going to talk about marriage equality. How it acquired constitutional protection involves two threads: the history of regulating marriage in America's federal system, and the history of criminalizing and then decriminalizing certain forms of sexual behavior. In the Judeo-Christian world, marriage has always been subject to regulation by the state. Canon law considered marriage a contract between the consenting parties and God, thus subject to regulation by the church. Eventually, the state came to replace the church, especially as English law developed after the Reformation. The state might not be a party to the union, but the state had a compelling interest in favoring stable family relationships. Marriage involved children. Children are dependents for whom the parents were responsible. Marriage involves property, and most important, marriage involves inheritance. And property and inheritance, and making sure that the kids' dependents are cared for, is something that the state has a huge interest in. And so the state, when I mean the state, I mean the official governmental units, set rules for who could marry and under what conditions and what their responsibilities were. English common law adopted what became known as coverture. It's a legal regime where the married couple had a single legal identity over which the husband had control. And based on its English roots, American civil law followed suit. Now, the introduction of race-based slavery introduced the issue of interracial relationships. The codes in early 17th century colonial Virginia penalized parties found to have had intimate sexual relationships. A white man who had relations with a non-white woman could be fined, although he rarely was. A white woman found to have had sex with a non-white man could be whipped or even reduced to becoming an indentured servant for a term of years. While English law was patriarchal, status was inherited from the father. The American colonies, especially in the southern colonies, and as Virginia did, adopted a law that provided that offspring of non-white women inherited their status from the mother. Thus, the child of a slave woman became a slave owned by the mother's owner. The interracial child of a white mother would become an indentured servant into his early 20s. And no slave could enter into a legal marriage. Marriage was a contract, and slaves had no standing to make a contract. Now, laws banning interracial marriage spread over the latter half of the 18th century and into the early 19th. Now, those laws were common in most of the new Western states. And I want to go here to share screen again. And let me go forward. The word miscegenation was coined during the Civil War by those who opposed Lincoln's reelection in 1864. And you see this here. This is political. These images are, you know, what miscegenation is, what we're to expect now that Mr. Lincoln is reelected, and a political cartoon opposing Lincoln's reelection that is called the miscegenation ball. This is where this word came from. In 1883, the Supreme Court held in a case called Pace versus Alabama that laws banning interracial marriage did not violate the 14th Amendment's Equal Protection Clause because both the white and the non-white party were treated equally. Marriage laws like divorce and probate had always been reserved to the states in our federal system. And let's see. As of 1945, all of the 15 former slave states and 15 others, mostly in the West, banned interracial marriage. But change came. And you see this in this laser color red, okay. You see this, here's the Western states. All of these Western states had anti banning racial marriage that lasted until after the end of World War II. These states had bans of interracial marriage that lasted until they were outlawed by the Supreme Court in 1967. Only in these few green states and these gray states, in the gray states, there were no laws banning interracial marriage ever. And in the green states, there were such laws, but they were actually repealed before 1887. And then came Loving versus Virginia, the case of Loving versus Virginia. And here's a plug I want to make. Many people saw the movie Loving, but there was an HBO film, and I think it's still available, called The Loving Story. It's a documentary based on the case, and it's a fabulous film. I've shown it to groups where I've talked on this before, and it's got every group I've shown it to thought it was tremendous. Here's the story. Richard Loving was a young white man from a small town in rural Virginia. He fell in love with a neighborhood girl that he'd grown up with, Mildred, who was mostly Indian but was considered Black under Virginia law. They got married in Washington, D.C. in 1958 because Virginia law prohibited it. But after they got married, they grew up in a rural small town. They went home these were people who, like many Americans, who basically had never have a desire. They grow up in a certain town and they want to live there they're happy living there the rest of their life. They went home back to Virginia, and shortly after they did, they were rousted out of bed one night and taken to jail. They were charged with the crime of violating Virginia's anti-miscegenation law. They pled guilty because they had no defense. They also had no money. And they were sentenced to a year in jail, but that sentence was suspended on the condition that they leave the state and not come back for 25 years. They moved to Washington, D.C., and there they had 3 children. But they hated living in the big city. And one night, when one afternoon, when one of their kids was almost hit by a car playing in the street, Mildred was just frantic, and she wrote to then Attorney General Robert Kennedy, who referred them to the ACLU. She was ready to leave her husband because she hated living in the city so much. Kennedy referred them to the ACLU, and the ACLU found lawyers for them. Because their convictions had been final for years, they were convicted back in 1959 or 1960. You can't just go back to court, file an appeal, and say, hey, this crime I was convicted of 5 years ago was wrong, I shouldn't have been convicted. You've got to get a current order for the court to rule on, because only a current controversy is something that a court can decide. So they made a motion to set aside their conviction and change the sentence to allow them to return to Virginia. The judge denied the request. And when he denied it, he wrote something for his reason. And it turns out that this actually was the best favor they could have gotten, because it was so outlandish in the context of the civil rights movement and the passage. And this is about the same time Congress, Brown versus Board of Education has been decided. Schools are being required to integrate. The Civil Rights Act had been passed in 1964. And here's what he wrote. God sent the races apart on separate continents, and but for interference with his arrangement, there would be no cause for such marriages. The fact that God separated the races shows that he did not intend for the races to mix, close quote. Now, the Virginia State Court affirmed the trial court decision, and the Lovings appealed, the Virginia Supreme Court affirmed the trial, did not hear the case, just one sentence denial. So the Lovings appealed to the Supreme Court, because you could, if it's jurisdiction of the Supreme Court, they have the power under a writ of certiorari to hear any case involving a question of federal law that has been decided by the highest court in the state. Now, neither Mr. and Mrs. Loving attended the arguments before the Supreme Court. They were uncomfortable as public figures, and there's images in that movie, the Loving story, of, you can see the reaction on their face when they're required to respond to reporters. When asked if he had anything to say to the court, Mr. Loving asked his lawyers to tell the court, quote, "Tell the court I love my wife and it's not fair that I can't live with her in Virginia," close quote. Now, I want to pitch this documentary. We know that California can be a harbinger of things to come. In 1948, a California Court of Appeal held that California's banning of interracial marriages violated both the 14th Amendment Due Process Clause and the California State Constitution. And when the Supreme Court caught up in 1967 in Loving versus Virginia, it was a 9-0 opinion. The Supreme Court held, one, freedom to marry is a vital personal right, one of the, quote, basic civil rights of man, close quote, and it's fundamental to the structure of society. Two, the state has no recognizable interest in regulating who may or may not marry based on the race of either party. And three, to deprive a person of this right solely on the basis of race goes to the heart of why the 14th Amendment was adopted. And it thus deprives the citizen of liberty without due process of law. That's the decision in the Loving case. And it again says that here you have a law that even goes back to something that even in the 1880s, the Supreme Court might have taken notice of, because here's a law that expressly discriminated on the basis of race. It said that you can marry this kind of person, but you can't marry that kind of person. Now, when the Supreme Court in Alabama said, hey, it's not discriminatory because both parties are treated alike, that bears the issue. Now, that brings us to marriage equality, because it's logical. It's impossible not to make the logical connection that if it's so fundamental that it cannot be deprived on the basis of race, why should it be deprived on the basis of sex? on the basis of gender. Are there any questions? Or should I just keep going?
I'm looking for hands. Was that Constantine? No. Okay.
Okay,
Go ahead.
let me keep going. So that brings us to marriage equality. In the Judeo-Christian tradition, both homosexuality and so-called deviant sexual behavior was considered both abhorrent and immoral. Church and state alike did their best to ban oral and anal sex for opposite-sex couples as well as same-sex couples. And American states reflecting Puritan and evangelical influences did the same. And you see this, if you look at the old criminal codes in states, you'll see this. It's called the crime against nature. And oral sex was expressly prohibited. Yet during the course of the 20th century, most such laws were rewritten or reinterpreted to apply only to same-sex couples. And homosexuality became a target. Military regulations adopted in 1942 gave examiners permission to disqualify men with, quote, feminine body characteristics, close quote, or who exhibited, quote, effeminacy in dress and manner, close quote. After the war, both Congress and the executive branches ferreted out gays and lesbians from public employment. And during the McCarthy era, the State Department expelled far more people for being homosexual than it did for being communists. They could, quite frankly, it was probably easier to tell one from the other. A 1950s policy statement issued by the United States Senate for employment in the Senate said, quote, and a statement was this, the title of their statement was employment of homosexuals and other perverts in government, close quote. And in the statement it stated, quote, one homosexual can pollute an entire government office, close quote. That's 1950. Up until 1973, the American Psychiatric Association classified homosexuality as a mental illness. Then called it, quote, sexual orientation, close quote. And it did so until the 1990s. The World Health Organization didn't remove homosexuality from the International Classification of Diseases until 1990. So we're not talking about past history. We're talking about current events here. Bias against homosexuality was so deeply embedded in Western society that the cultural shift from 1990 to 2005 took place at historical light speed. And I found something that illustrates this. This is change over, just a minute, I did something wrong. This is change over time, marriage equality and changes in the laws of the states. In 2008, you look at this, states that banned it by statute are light yellow, states that banned it by state constitutional amendment are dark yellow. States that expressly legalized it are in dark gray, and light gray is states that don't mention it at all. And so you look at this over the years. 2008, 2009, 2010, 2011, but then 2012, 2013, 2014, 2015. This is what I call historical light speed.
It is indeed.
Changing laws and court decisions decriminalized homosexual relations between consenting adults. LGBT people were guaranteed human rights on the same terms as heterosexual people. And the military went from disqualification of all homosexuals as serving to don't ask, don't tell, to we don't care. And in 2015, the Supreme Court made marriage equality the law of the land. Now, let me get out of here. As recently as 1986, at least this is recent to me, The Supreme Court in Bowers versus Hardwick upheld a conviction under Georgia's anti-sodomy law and held that the 14th Amendment does not prevent the state from enforcing a criminal charge, even if the case of consenting, it's a matter of consenting adults in the privacy of their home. And in Bowers, it was two gay guys who were charged with violating sodomy laws. In 1990, according to polls, over 70% of Americans disapproved of gay marriage. And although Bill Clinton believed that gays should be permitted to serve in the military, and if you remember when he ran for election president in 1992, he promised that he would change that. Political considerations limited him to instituting don't ask, don't tell by executive order. He couldn't get Congress to approve a major change, and he knew that for political reasons, this is as far as he could go. But there were harbingers of change. In 1982, Hawaii's highest court held that marriage equality was required under its state constitution. In 1996, in a case called Romer versus Evans, the Supreme Court had to consider the case of a Colorado constitutional amendment that had been adopted by Colorado's voters. The amendment stated that this amendment put a provision in the Colorado state constitution that effectively repealed all existing laws in the state that protected homosexual rights and prohibited the state of Colorado and any local governments in Colorado from enacting measures that ban discrimination based on sexual orientation or preference. In other words, Colorado's voters adopted a provision that in effect made discrimination against gays the law of the state. Justice Kennedy's opinion for a 6-3 majority said that any law that singles out a specific group to be discriminated against must pass the test of strict scrutiny. In other words, was the state's interest so compelling as to warrant the discrimination that's complained of? And here he found this was not the case. He said and wrote that this provision, quote, classifies homosexuals not to further a proper legislative end, but to make them unequal to everybody else, close quote. Now there's pushback to Romer versus Evans, because that decision was decided in May of 1996. In September of 1996, the Republican-led Congress passed DOMA, the Defense of Marriage Act, and they passed it with veto-proof majorities. Now, the act limited all federal benefits that were based on marriage only to opposite-sex couples. That means filing joint tax returns, inheritance tax exemptions, et cetera, et cetera, et cetera. Now, remember, Congress passes in September 7, 1996. Clinton's up for re-election 2.5 months later. He had no choice but to sign it. He's up for re-election. If he vetoes it, that could be a death knell. So he signed it. Nevertheless, in 2000, Vermont enacted the country's first civil union statute, and other states too soon followed. And then in 2003, the court accepted a case on the same issue that had been decided in Bowers. In Lawrence versus Texas, by a 63 vote, the Supreme Court overturned and overruled Bowers, and it held that criminalizing gay sex by consenting adults in private violated the 14th Amendment's equal protection and due process clauses. The opinion was written by Justice Kennedy, and he framed it in terms of personal liberty. Quote, liberty protects the person from unwarranted government intrusions into a dwelling or other private places. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate contact, close quote. So intimate sexual acts between consenting adults in private are, quote, within the liberty of persons to choose without being punished as criminals, close quote. This is Kennedy. Kennedy, if you look at all of his votes on Citizens United, you're saying this guy is no liberal. He's not. but at least he's true to his belief, what you would call libertarian beliefs, that there are certain places that people have certain rights that are beyond the scope of government. Now, this goes back to a basic fundamental divide over the relationship between the importance of the individual in society and the importance of the collective in society. And there are times when you sure want to favor one, but there's also times when you sure want to favor the other. Because if you go to issues of economic fairness and economic opportunity and access to opportunity, then I would say that you could make a pretty good argument that the group is more important than the individual. And a progressive tax policy that, in effect, people who make it well have an obligation to help support and provide for a decent lifestyle for people who don't, is right and proper. But when it comes to this, the individual should be favored. Personally, I think Kennedy is absolutely right here. The opinion noted that 25 states had anti-sodomy laws when Bowers was decided, but as of 2003, only 13 had. Justices Scalia, Thomas, and Rehnquist dissented. They basically said Texas's anti-sodomy law may be bad policy. It may even be stupid, but there's nothing in the Constitution that creates a fundamental right of privacy. Scalia aptly noted that if moral disapproval isn't sufficient to uphold such laws, then same-sex marriage must be allowed. And he wrote that in 2003 in his dissent in Lawrence versus Kansas. Let's continue with the story. In 2004, Gavin Newsom, mayor of San Francisco, remember what he did? He ignited a firestorm when he instructed the city clerk to issue marriage licenses to gay couples. About 4,000 couples were married. But then the California Supreme Court stepped in and says, hey, wait a minute, mayors can't decide what's constitutional. That's the job for the courts. And it issued a stay while it decided the case, and then decided the case that mayors don't have the policy to do this. And the state of California then sent out oops notices to the 4,000 couples who had been married in Cisco, saying, guess what, folks, you're not married. So what happened then? In 2005, and again in 2006, California legislature passes gay marriage laws, but Governor Schwarzenegger vetoed them. Then in May 2008, the California Supreme Court ruled 4-3 that marriage was a fundamental right under the California state constitution. And therefore, California statute defining marriages between a man and a woman violated the state constitution because there was no compelling reason for the California state constitution to bar gays from the, quote, most socially productive and individually fulfilling relationship that one can enjoy.
And another thing too.
Are we?
Yeah, somebody unmuted themselves. You need to unmute yourself again, Arthur. I just muted all.
I'm going to have a break for questions in a minute, and we're going to have time for them. So please bear with me. Let me get through this. In May 2008, the California Supreme Court ruled that marriage was a fundamental right under California's constitution, and thus a California statute defining marriages between a man and a woman violated the state constitution. There's no compelling reason for California to limit marriage to only to same-sex couples, opposite-sex couples. A month later, Proposition 8 was certified for the November ballot. So a month after the California Supreme Court rules the California Constitution can't ban gay marriage, Proposition 8, which amends the Constitution to do just that, was certified for the ballot. It got enough signatures. In November of 2008, California's voters did something really weird. They overwhelmingly voted for our first Black president, yet they adopted Proposition 8. Now, Proposition 8 was then challenged in federal court as unconstitutional under the 14th Amendment. And here I got another plug I'm going to make for a HBO film called The Case Against 8. If you haven't seen this, I think it's still available on HBO. Please watch it. It's fabulous. It's a story. It's one of the most compelling documentaries that I've ever seen. And there's a book on it called Speak Now, Marriage Equality on Trial, the story of this case, Hollingsworth versus Perry. Kenji Yoshino is a professor of constitutional law at NYU. And I was very fortunate. I got what's called a pre-publication copy of the book when I was teaching at UCLA, asking me to comment on it as a constitutional scholar, which I was glad to do. I said, you have to publish this book, and I highly recommend it. Now, Jerry Brown, then the state's attorney general, refused to defend Proposition 8, and Governor Schwarzenegger agreed. So the proponents of Proposition 8 were allowed to step in and defend the proposition in federal court. The case went to trial in the Northern District of California, and the judge, after a lengthy trial, found that Proposition 8 was motivated by objections to homosexual life, and there was no other reason for it. And thus the state had no compelling state interest in denying marriage equality, and Proposition 8 was therefore unconstitutional under the 14th Amendment. And this was a federal court in the Northern District of California. And the Ninth Circuit appealed it, Ninth Circuit affirmed it, and the proponents appealed to the Supreme Court. Now, in those years, the ACLU and other groups filed a court challenge to the constitutionality of DOMA, the Defense of Marriage Act. Both the challenges to DOMA and the California Prop 8 came to the Supreme Court during the 2012-2013 terms. And the decisions on them were announced on the same day. And I know I watched it on television. The Supreme Court in Hollingsworth versus Perry ruled that the proponents of Proposition 8 didn't have standing to appear before the Supreme Court. They didn't care that the lower courts had said they had standing. They said, hey, you can't appear in this court unless you have standing. In other words, is there anything about this case that's going to personally hurt you if we decide one way or the other? And the court held 5-4 that the proponents of Proposition 8 would suffer no harm no matter which way the case was decided, which had the effect of leaving Proposition 8, the order in the federal district court that Proposition 8 was unenforceable, was a final judgment as far as California was concerned. And marriage equality became the law in California. Now, what about US versus Windsor? The court, and by the way, it's interesting, in that 5-4 decision, 2 of the justices who dissented would rule that marriage equality should be the law, and 2 of them ruled that it shouldn't be the law when they had the chance to do so. In US versus Windsor, a 5-4 decision, it was held that DOMA was unconstitutional under the Fifth Amendment's due process clause. Remember, DOMA is a federal law, so it's determined by the Bill of Rights, not the 14th Amendment. The case facts were compelling. Windsor and her gay partner had lived in New York together for over 42 years. They got married in Canada in 2007 because at that time, Canada allowed gay marriage. New York adopted a gay marriage statute in 2008. Windsor's partner died in 2009 and left Windsor as her sole heir. As I said, by that time, New York had legalized gay marriage, so their union was recognized under New York state law. Windsor, but after her partner died and they go to probate the estate, Windsor is hit with a federal estate tax of some $360,000. Now, she wouldn't owe that money if the IRS recognized their marriage, which New York recognized. But under DOMA, the IRS could not recognize their marriage. So that's why she had this tax bill. Kennedy, joined by Ginsburg, Breyer, Sotomayor, and Kagan, noted a number of things. One, marriage has always been determined by state law. And if a state legally recognizes same-sex marriage, the federal government has no reason to treat it differently. Federal government can't treat same-sex married couples differently than it treats opposite-sex couples in the same state. That's a violation of the Due Process Clause of the Fifth Amendment. The Constitution obligates the federal government not to violate basic due process and equal protection principles. So DOMA's principal effect is to identify a subset of state-sanctioned marriages and make them unequal. Because the court noted that at that time, almost half the states allowed gay marriage. And so, in effect, DOMA said that people who live in those states that allowed gay marriage had to pay were recognized under federal law differently than opposite sex couples, and that the federal government could not do. The court noted that DOMA, quote, imposes a disability on the class, same-sex married couples, by refusing to recognize a status lawful when and where that status was created or where it's relevant without any compelling interest to do so. Now, when Windsor was decided, in 2013, this is the status of same-sex marriage. And you'll see it's all over the place. The dark blue states legalized it. The dark red states banned it in their state constitutions. The light red states banned it by statute. The light gray states had no specific provisions one way or another. Dark gray states said, well, it's not legal here, but we'll allow it if it's legal where performed. And some states had civil union statutes. They're literally all over the place. If you Google and go to Google Images and do same-sex marriages, you'll find these images. That's where I got it. But 2 years later, it was different. This is the status of same-sex marriages as of February 2015. And you can see that in vast majority of the country, it's legal, either because the states themselves have done so, or because district courts, federal circuit courts having jurisdiction over those states, said it was legal under the 14th Amendment. And so in 2015, the court has the opportunity to decide whether or not same-sex marriage has to be allowed under the 14th Amendment. The case is Obergefell versus Hodges. And so the issue was, did state laws banning same-sex marriage violate the 14th Amendment, period? And the same 5-4 majority that decided Windsor held that it did. I think can I get rid of this image? Have you all seen it? Not if you haven't, okay, I can let it go. The same 5-4 majority that decided Windsor held that it did. Kennedy again was the swing vote and wrote the opinion. He was a libertarian, not much more than a doctrinaire conservative. And his opinions in both Windsor and Obergefell revealed that he understood that American attitudes were becoming more accepting of same-sex relationships. Kennedy understood that marriage is essentially a conservative institution. You can't call marriage anything other than conservative. Why? It's instrumental in fostering a social order predicated on stable family relationships. Through marriage, people acknowledge their mutual dependence and their responsibilities to each other and to their dependents. This is what he's writing. And for Kennedy, the question isn't who may exercise that right, but who may not. And if not, why not? The state has to have some overwhelming interest that justifies excluding a disfavored class. The 14th Amendment means that people do not have to rely on the democratic process to enjoy the exercise of a fundamental right. And there he's taking language from Scalia. Scalia says, hey, if gun is a personal right, it's not subject to, personal rights aren't subject to a vote. If it's a right, it's a right. They're not conditioned on votes or public acceptance of their importance. That decision is made by the Constitution. Now, the dissents mirrored the same dissents that they'd made 2 years earlier. Roberts argued that the government has legitimate interest in preserving the traditional definition of marriage. Alito noted that due process only protects rights rooted in the nation's history, and marriage has always been a state issue, not a constitutional one. In other words, Alito has no problem with different states having different rules. He feels that good people differ, and Alito makes a point that's interesting. He said that the problem with finding that same-sex marriage is lawful throughout the country is in effect saying that homosexuality is okay, and that people opposed to that on moral grounds will now be branded as bigots and held up to ridicule. That's a point and Scalia and Thomas, of course, take an originalist approach. Since the authors of the 5th and the 14th Amendments would never have thought about these provisions in the context of marriage, same-sex marriage, the court can't now properly claim it's a right arising under the Constitution. When we were starting out, before I began, I was asked if I thought, one of you mentioned that Justice Scalia says that this issue, now with Justice Barrett's coming on the court, this issue is open to revision. I think on this one, the issue is over. Well, wedding bells have been rung for millions of Americans, and it's an axiom of legal truism that you can't unring a bell. You can't unring the bell and dissolve their unions. It's it's been accepted for too long in too many places by too many millions of people. There are too many same-sex families with too many children to now change the rules, And I think a majority of Americans have accepted and agreed that this is right and proper. So in my opinion, I don't think you're gonna, as much as Justice Barrett feels that this was wrongly decided, I think when you stop and think about how many gay marriages there are, how many children are living in these relationships, how many states have now accepted them, and how many Americans now think this is okay. I think that's my answer, is I think that Justice Thomas and Justice Alito, when they say this is open for reconsideration, I think when it gets there, they might dissent, but I think a majority of the court, I think Roberts and a majority of the court are going to find otherwise. So that's my take on these two cases. I got 5 minutes, it's 5 minutes to 12. The floor is open.
Questions, anybody?
Go ahead and unmute yourselves.
Irene.
Yes, I'm just thinking that 2008, the California amendment decision, a measure decision, was a surprise to everyone. What makes you think that the same thing wouldn't happen if this came up in court again for the Supreme Court? If that could happen in California when you give the decision to the ordinary people, what guarantee is there that the Supreme Court won't overturn if it comes up again?
When Proposition 8 was voted upon, there were very few gay marriages in California. Remember, the California Supreme Court upheld gay marriage in May of 2008, and gay marriage and Proposition 8 was voted on that following November. So you didn't have millions of existing marriages now being declared invalid. You didn't have millions of families being disrupted. And the fact that when you look at it, if you look at the vote in California, the number of people that actually voted on Prop 8 was a small percentage, was less than half of the people who voted on the issue of who should be president. In other words, that down ballot did not get a lot of votes. And so I think that the question, it's not, it's unlikely that it could happen again, because now you have probably 20 to 30 million people in the United, out of 10 to 15% of America's population is involved in these kind of relationships.
I just am concerned that it's raised lots of other issues in the interim, cases of discrimination against gays, etc., which makes me think that the issue is still not settled.
Well, one of the things I used to tell my students when I taught at UCLA, Irene, was that if you want answers, go take a chemistry class. That up here in the history classes, we only have questions. Because no, when it comes to this stuff, all you can do is look at all I can do is look at all the facts, look at how cases have been decided in the past, take into account what I know about historical past, and express an opinion. I was asked, what's my opinion? Do I think that this is going to be revisited? I don't think so. And I've given you my reasons. Reasonable people can differ, but I've given it my best shot. I think that the analogy between Proposition 8 being adopted and now gay marriage being revisited to undo are two different issues. But that's my take on it.
Other question? Yes, Sandy.
How difficult would it be to separate the issue of inheritance and marriage?
Extraordinarily difficult. Married couples have community property. Tax law gives assets that are held in community property receive a step up in basis upon death of the first spouse. So you have an inheritance taxes is based on the values as of death. And if there's a step up in basis, it eliminates the tax. So there's a tremendous amount of play here. Survivors' benefits under Social Security are based on marriage.
Yeah.
You have states that have community property law. If people are lawfully married, there's community property law has an automatic right of survivorship, and you have co-ownership over property. If they're not married, all you have is joint tenancy, and you don't have the same protections. Joint tenants don't owe a fiduciary duty to each other. Married couples do. So what one person can do if property is held jointly, if property and by an unmarried couple together, there's nothing that prevents one person from severing the joint tenancy by conveying his half interest in the property to somebody else. A married person can't do that without his spouse's consent. Children inherit, adoption laws require people to be married. It's very difficult. An unmarried partner does not have the same rights as a married partner over a child that's been adopted by a single parent. If the couple isn't married, adoption has to be by a single parent. If something were to happen, the other parent, the other adult in the household would not have any rights. So that's another example. I could go on. Oh, how about the right not to testify against your spouse? How about privilege? That statements made by a married couple to each other are privileged and private. They should be able to talk to each other and not be worried that someone could compel them to say their private deliberations. If they weren't married, those rules don't apply. It goes on and on and on.
I did see Lou's hand.
Lou, talk to me.
You got to unmute yourself again, Lou.
There we go.
Yeah.
This has been a wonderful, wonderful course. I look forward so much to your next installment next year.
Thank you. I don't know when that's going to be. I'll tell you, I was just sworn in as a member of the county civil grand jury, which is going to I don't know if any of you folks know what that is, but I'm going to be committed to 20 hours a week until next June. So it may be that my next course is going to have to wait until next fall. But I promise I will get back to this.
You'll have time. I did 2 years on the civil grand jury. A lot
You
of it
think I'm
is-
going to have time to prepare a class while I'm also on the civil grand jury? You have no
Well,
idea how many
do it.
hours go into doing this.
Yeah.
You should teach us how a grand jury actually operates when the thing is over.
I'll be happy to do
I'd
that.
really like to hear that. Thank
Yeah,
you.
that would be very interesting.
That's a good idea.
Yes.
Yeah.
No secret, you know, none of us who have not been on it really know how it works.
Okay. Any other questions on today or any of the other classes, any of these 4 classes? Well, this has been my first experience.
Thank you so much. Wonderful.
Thank you. This has been my first experience teaching for OLLI.
You did great. We loved it.
Okay.
Yes.
All right. Well, thank you. And I'm going to go have lunch.
Enjoy your
Bye-bye.
lunch.
And
Well
I
deserved.
Thank you.
Thank you
Thank
all.
you, Arthur. Thank you, everybody else.
Bye-bye.
Thank you.
Everyone.